My lords, my lady, I had gone on to address the issue of whether the decision of the first-tier tribunal was flawed by error of law. The appellants making out their case in two parts. First, that they erred by considering the interviews, and second, by virtue of a misdirection on onus of proof. I've already addressed the matter of the proposition that the interviews were disproportionate, arbitrary, and abuse of power, when in fact they were performed and carried out in discharge of a statutory duty and obligation. A perfectly legitimate entitlement to investigate existed and was pursued. As regards the suggestion that the interviews somehow contained an inherent element of unfairness because of their unexpectedness, perhaps I could just take your lordships to MS 99, which is the opinion of the first-tier tribunal, MS 99, paragraph E.
Yes.
And one might consider what's said here in light of my learned friend's submissions. In her oral evidence, the first appellant stated that the Registry Office wedding plan for 17th April 2014 was a dry run, and that both appellants anticipated that because the second appellant is an overstayer, they may not be allowed to marry. They did not want the disruption of a visit from immigration officers at a more elaborate wedding ceremony, and so they thought they would try their luck at a registry office without family members. If they were successful, they would have a larger celebration of marriage with all relatives there. There is a difference between what the appellant said at interview and what the first appellant said in her oral evidence. So it doesn't appear that the presence of the immigration officers was quite the surprise that might otherwise be inferred from the appellant's case. While on that page, could I just pick up on a point my learned friend made this morning about the first-tier tribunal making an error as to whether the first appellant's mother was in Lithuania. And if I can just refer to paragraph D at the top of that page. The starting point is the records of interview. The first appellant and second appellant were found at Leith Registry Office, where they were expected to be. The first appellant was asked why her mother and two sisters, who lived in Edinburgh, were not at her wedding. She stated that her sisters were busy with other commitments and her mother could not come because of her age, and that her mother did not know that the marriage was taking place. And then at F, the second appellant was asked why the first appellant's mother was not present, and he replied that the first appellant's mother was not at the wedding because she lives in Lithuania. The second appellant says that the first appellant's family know about the wedding. The second appellant says that the first appellant's family know about the wedding arrangements. So, I mean, putting aside the clear contradiction between the first appellant and the second appellant about the mother's knowledge, reading paragraph D and allowing for the relevant punctuation, it doesn't appear to me that the FTT is saying that the mother was in Edinburgh. He's saying that the two sisters were in Edinburgh, and indeed he goes on to record the reference to the mother being in Lithuania in paragraph F. But it's perhaps a somewhat minor aside, but this is what happens when at this appellate level parties begin to indulge in a reanalysis of the factual matrix that was relied upon by the original fact-finding tribunal for the purposes of their determination. Now, moving on from the question of the interview to the question of onus of proof and the suggestion that there was a misdirection on onus of proof. Yep. Reference was made to paragraph 21 of the Inner House opinion, and I wonder if we could just go back to that for a moment and read it in full. It's to be found at MS 80.
Yep. You want to read that? Or are you going to read it?
I'm happy to read it, Lord. It will take but a moment once I've found it. There is no error of law in stating a general proposition that in immigration appeals, the legal burden is on the appellant. The evidential onus may fluctuate thereafter, depending upon the particular circumstances. In this case, for example, in the first appellant situation, proof of her nationality and consequent residency card would shift any burden onto the respondent to demonstrate that the proposed marriage, which put her residency right in jeopardy, was a sham. Whether the same considerations apply to the second appellant is doubtful. However, the FTT considered the information and reached a decision based upon it. That decision did not depend upon onus, but upon weighing the various factors in the balance. In that context, there is only one standard of proof, that being the balance of probabilities. And also, I just pause to observe that what the inner house is addressing is the general proposition that in immigration appeals, the legal burden is on the appellant. Now, why would it be on the first appellant? Because she has to come in and say, I am an EU citizen. I have a right to be here. And of course, as the inner house themselves immediately acknowledge, that is discharged very rapidly, and the onus then rests upon the respondent to demonstrate that the proposed marriage, which puts her residency rights in jeopardy, was a sham. And that, I respectfully submit, takes me back to the original proposition that I began with as to what the real issue in this case is. And indeed, the FTT at paragraph 7 addressed the same general proposition at paragraph 7 MS 96. I won't go to it, but again, they're talking about the very general issue of onus and standard of proof, and that is all they're addressing. There was no suggestion that the onus of establishing whether the marriage was a sham or whether it was a genuine marriage rested with either of the appellants.
It might be said that anyone reading paragraph 7 and then reading what follows would think that what the tribunal FTT was saying was that on every issue, the burden of proof was on the appellant.
Well, I invite the Lord to read the FTT judgment as a whole, because in my respectful submission, that's not the case. And indeed, it wouldn't easily sit with the direction of travel by the FTT, because what the FTT then did,
yes,
having identified the standard of proof, was to recognize that there was evidential material supportive of a genuine marriage. That's where they began. That's at MS 97 to 98. And they went through all of the evidence supportive of a genuine marriage at paragraphs 11E to J and at 12B of their judgment.
Yes, what I've got really in mind is if you start with paragraph 7, they say in immigration appeals the burden of proof is on the appellant. Standard is balance of probabilities. That seems to be a general statement.
Very much a general.
Then talks about human rights appeals for the appellant to show, and then he talks about a shifting burden if he shows that there is an interference with human rights. No suggestion of a shifting burden in relation to the first point made.
Well, in my respectful submission, one's got to bear in mind that he was dealing with two distinct issues as regards the first appellant and the second appellant. And he goes on to deal with the second appellant by looking at it in the context of what was developed as an Article 8 case. And of course, the onus was on the second appellant to discharge his right to claim the appropriate connection for the purposes of Article 8. But at the end of the day, my lords, what one sees is actually this. The first tier tribunal went on to consider all of the evidence in context. It reached a view on the facts that it was entitled to reach. And by that stage, the issue of onus was not of itself material, because the issue of onus would only have arisen if the tribunal had concluded that this is a case where we cannot decide, we cannot make a finding of fact, and therefore we have to fall back on the question of who has the onus to discharge. And in that context, of course, the onus with regard to whether or not it was a sham marriage would have fell to the respondents. Nobody doubts that for a moment, and indeed the inner house itself acknowledged that. And we refer in the case to a number of authorities. Reference has already been made to the case of Sanderson, yes, but also the case of Thomas, which is at MS 1103. Thomas against Thomas, a case in the House of Lords of some antiquity, I acknowledge.
Yes, we go to 1103.
And I don't think I need to read the entire passage. It's merely making the point that once the evidence is out, the issue of onus really doesn't arise. The same point's made in Milne and Sanderson, but I'd also mention the case of Ali that my Lord Reid opined in. That's at MS 1580. And a decision in 2016 in the Supreme Court, paragraph 32. Perhaps I might just read out this paragraph. Whether the situation is analysed in terms of positive or negative obligations is, however, unlikely to be of substantial importance. Whether the person concerned enjoys private or family life in the UK depends on the facts relating to his relationship with others, whether, for example, he is married or has children. Where he does enjoy private or family life in the UK is a right under Article 8 to respect for that life, whatever his immigration status may be, although that status may greatly affect the weight to be given to his Article 8 right, as Jonas' case makes clear. Whether one poses the question whether striking a fair balance between the interests of the individual in his private or family life and the competing interests of the community as a whole, his right to respect for his private and family life entails an obligation on the part of the state to permit him to remain in the UK, or whether striking a fair balance between the same competing interests, his deportation would be a disproportionate interference, one is asking essentially the same question. It is true, as counsel pointed out, that the onus is on the state to justify an interference, whereas there is no such onus on the state to demonstrate the absence of a positive obligation. But questions of onus are unlikely to be important where the relevant facts have been established. Ultimately, whether the case is considered to concern a positive or a negative obligation, the question is whether a fair balance has been struck. So once the evidence is out, the question of onus really is superseded. And that's the point also that was made by the Inner House in their judgment at paragraph 21.
Well, if I'm being quoted, perhaps I might observe that their onus is being referred to in relation to the where the burden of justification lay once relevant facts had been established. And in the present case, we're more concerned with onus in relation to the establishment of a relevant fact.
But here we have all the factual matrix laid out. And the first-tier tribunal is then coming to a view as to what that points to, whether the marriage was genuine or whether the marriage was a sham.
Well, did the tribunal have to be satisfied on the balance of probabilities that it was a sham?
It said so in terms of paragraph 7.
Would you accept that it did have to be satisfied?
Yeah. And it said so at paragraph 7.
Just refer me to paragraph 7 again, please.
Paragraph 7, my lords, is at MS 96.
96.
Now, my learned friend this morning also referred to...
So, sorry, just to go back to paragraph 7. If that is established, and that is the question of whether there has been an interference with human rights, his or her human rights, it's then for the respondent to establish that the interference was justified. But my question was a rather different one, and that is, did the respondent have to satisfy the first-tier tribunal on the balance of probabilities that the marriage was a sham?
It would be for the respondent to justify the interference which arose by virtue of the enforcement notice that was given on the 17th of April. And it could only justify that by establishing on the balance of probabilities that the marriage was not a genuine matrimonial contract, but what is termed a sham.
But this is talking about justification. It's not talking about whether or not the marriage is a sham.
If that is established and the relevant article permits, it's then for the respondent to establish that the interference was justified. The interference, in the case of the first appellant and the second appellant, is distinct.
Well, the judge is speaking about human rights appeals, which he distinguishes from immigration appeals. And Ms. Sadovska's appeal is categorized as an immigration appeal.
Indeed.
Whereas Mr. Malik's, I think, has one of each. He has an immigration appeal based on the EU regulations, and he also has a human rights appeal based on Article 8.
Indeed.
But what's meant by the last sentence of that paragraph? The appropriate standard of proof is whether there are substantial grounds for believing, and that's put in quotation marks, substantial grounds for believing the evidence.
It is underlining the fact that the reliability and credibility of the evidence given is also a material factor.
Well, we do accept that there are two different contexts to be considered here. The first is whether the marriage is a sham, and the second is whether there has been an interference with an established human right, convention right.
Under Article 8, which was not pursued.
Yeah. No, but do you accept that there are two different contexts?
The primary context is the interference. The secondary context arising only in respect to the second appellant is the Article 8 case that was put.
No, I'm sorry. I'm putting to you two different contexts. One being the issue whether the marriage was a sham, the other being whether there's a justified interference with the convention right. Do you accept that those are two different contexts?
Well, in both instances, the onus would rest upon the respondents.
Yeah, well, I do accept that at least that's the case that's made against you, that the onus rests on the respondent. But my point is that in paragraph 7, the tribunal judge appears to be addressing only one context, namely whether there's a justified interference with the convention right. He doesn't appear to be addressing the other context, namely whether this was a sham marriage.
No, my lord, in my respectful submission, that's not the case. It begins by saying in immigration appeals, the burden of proof is on the appellant, and the standard of proof required is a balance of probabilities.
Well, what's that got to do with anything? Well, that doesn't address the point that I'm putting to you.
Well, with respect, that is where the first-tier tribunal was addressing the matter of an immigration appeal. It then goes on to look at inhuman rights appeals.
Is it ever anywhere said in the first-tier tribunal judgment that the respondent has to establish as a matter of probability that this marriage was a sham?
In my submission, comes across quite clearly from paragraphs 11 and 12.
Let's just have a look at those then.
My findings of fact. And then the conclusions.
Well, I'll have to read that. I'll not interrupt you any further.
Well,
I'll have to read those very carefully
yes,
to see whether that emerges.
MS 101, paragraph P, it is beyond dispute that the second appellants and so on, in the degree of planning.
One of the difficulties that I think there may be is the fact that arises from the fact that the judge didn't relate his decision to the regulations. And forgive me if I'm wrong about this, but as far as I can see, the regulations provide that the decision to remove on the grounds of abuse of rights can be taken by the Secretary of State, where first of all there are reasonable grounds to suspect the abuse of a right to reside, and secondly it's proportionate to do so. I'm not suggesting that applying that approach he would have arrived at a different outcome, but it is a different approach. You're directing your mind to different issues.
Arriving at the same goal in my submission, because it's quite clear from the FTT's findings of fact that they were abundantly satisfied that this was a sham marriage.
Do correct me if I'm wrong about that. I'm looking at Regulation 21B.
21B-C, subparagraph C, I believe the law is.
No, that's 19.3C, says or provides that the EEA national, in other words, Ms. Sadovska, may be removed if the Secretary of State has decided that her removal is justified on the grounds of abuse of rights in accordance with Regulation 21b2. And then when you look at 21b2, it provides that the Secretary of State can take that decision where there are reasonable grounds to suspect the abuse of a right to reside and is proportionate to do
Yes,
so.
indeed. And the FTT found that the Home Secretary had reasonable grounds because he found that there was an abundance of evidence pointing to the fact that this was a sham marriage.
Yes, so I suppose on an appeal to the FTT, it becomes a matter for the FTT judge to decide, first of all, whether there are reasonable grounds for suspicion, and secondly, whether it's proportionate.
Yes. The FTT judge could have turned around and said, well, I've looked at all the evidence, and it seems to me that the Home Secretary had no reasonable grounds to suspect that this was a sham marriage. I'm entirely convinced that both appellants are reliable and credible witnesses and that their account of a genuine relationship should be accepted. He went completely the other way. He said, I don't regard them as credible and reliable for a variety of reasons. And looking at the evidence as a whole and weighing it in the balance, I'm satisfied that the Home Secretary could arrive at that conclusion because there's an overwhelming body of evidence to indicate that this is a sham marriage. One further point that my learned friend alluded to was the contradiction, the solecism, between what the appellants were asserting before the FTT and what they'd said in the signed statement dated 28 March that accompanied the letter of 11th April 2014. And as your lordships will be aware, that case at paragraph 23 is that this was not, this contradiction was not put to the appellants before the FTT. And that, well, that being the case, the FTT should not be faulted for not having regard to it. But he then corrected that and said, actually, I'm wrong about that. It was put to the appellants before the FTT. I don't understand that to be the case at all. My understanding is that the statement was before the FTT because, as you know, the tribunal judge noticed its terms, but any attempt to explain the contradiction only arose before the upper tribunal. And I'll stand corrected by my learned friend if I'm wrong about that, but we have no record or note of the point being explored before the FTT, and we've looked again at that. It does appear that it was after the event. So the FTT can hardly be faulted for not addressing an issue that wasn't raised. And in that context, I think it is worth pointing out the observations again of my Lord Reid, and I do with some degree of trepidation because he'll contextualise his observations. But in the case of HA and the Secretary of State for the Home Department, which is at MS 1366, if I could take your lordships to it. Because this really, it seems to me, it's very similar to the complaint the appellants make here. Your lordship observed there is, at paragraph 7, there is, on the other hand, no general obligation on the tribunal to give notice to the parties during the hearing of all the matters on which it may rely on reaching its decision. And then he illustrates that point by reference to a number of cases. And then at paragraph 12, he goes on to observe there's no general unfairness in proceeding in that way, since an applicant can generally be expected to be aware that the tribunal will have to assess its credibility and the consistency of the account was given in evidence with any previous accounts contained in the documents before the tribunal, which will plainly be relevant to the assessment. And at the foot of MS 1367, this general approach is consistent with that adopted by the courts in relation to other types of adversarial procedure in the context of criminal proceedings, for example, and then reference is made to the judgment in Hunt. Now, I just draw your lordship's attention to that. The point is this, that there was an opportunity. The appellants were legally represented before the FTT, as it were, before the upper tribunal. And if they wanted to advance an argument about whether or not anything should turn on the inconsistency between the statement of 28th March and the position adopted by the appellants in interview, then it was open for them to do so. But they have to recognise that the tribunal, having been appraised of that contradiction, was entitled to look to it when assessing issues of reliability and credibility. And there's no answer to that to say that after the event and when they went before the upper tribunal, they then came up with an explanation. So, as I say, I don't really follow the point my learned friend makes when he cracks his written case by deleting the word not. That doesn't seem to me to be entirely accurate. And if one reads on in the case, one can see the point they're actually trying to make, they're endeavouring to make. And I would suggest that the observations of my Lord Reid are of some relevance to that question. So, my Lords, at the end of the day, it respectfully appears to me that the FDT reached a view on the facts that it was entitled to reach. There was no error in law that would prompt this court in particular to interfere with the findings that were made. Can I turn on from there then to deal with the final argument that was introduced into the written case based on Article 28? This is the assertion that the first appellant had or has a permanent right of residence in the United Kingdom, with the result that the relevant test to be triggered before any enforcement notice is brought is that set out in Article 28, paragraph 2 of the regulations. Now, I accept, my Lords, that there's no jurisdictional bar on the court entertaining a new argument in a proper case. But it should not do so if it would be unfair to either party or would put the court in a potentially untenable position. A reference has already been made to the observations in the case of Miskovich in the Court of Appeal. That's at tab 40. At 1408, MS 1408, there's Lord Justice Morbick's observations at paragraph 134 of that case, where he said, "I'm not persuaded that the decision in Hooper binds us to hold that this court has no jurisdiction under any circumstances to entertain an argument of law that was not raised before the tribunal, and if that is so, the matter becomes one of discretion. In my view, the expression, any point of law arising from a decision made by the upper tribunal, is to be interpreted as including a dispute about the correct application of any principle of law on which the tribunal's decision depends. That is sufficient to found the court's jurisdiction to entertain the argument, but it does not follow that the court should routinely exercise its discretion in favour of doing so. On the contrary, the court should, in my view, be slow to allow a party to alter its case at such a late stage, and should rarely, if ever, do so in a case where all facts potentially relevant to the correct determination of the new point have not been found by the tribunal below, or where to entertain the point would be for some other reason unfair to the other party." And I lay considerable emphasis on the observation where all facts potentially relevant to the correct determination of the new point have not been found by the tribunal, because that is most certainly the case here.
Of course, the opportunity would exist if we remitted it to the tribunal for facts to be found.
Such opportunities always exist in the law, but the point being made is that those findings, in fact, have not been made, and were not made because the point was never raised before the tribunal.
Well, do you accept that she would have an enhanced right to protection
No, my Lord.
if she established that she was entitled to a permanent right of residence?
Well, that would apply to anyone.
Yeah. Well, you do accept then that if Miss Sadovska established that she had a right to a permanent right of residence, that would give her enhanced protection.
As I said, my Lord, that would apply to anyone in those
Well,
circumstances.
we don't need to debate whether it would apply to anyone. It would apply to her In those circumstances, the question for us, if we're dealing with questions of equity, is whether she should be denied the opportunity of having a finding made in her favour to that effect.
Well, it's not a matter of equity, my lord. This is the Supreme Court. At the end of the day...
well, the Supreme Court isn't a stranger to equity, I
I
hope.
appreciate that, my lord. Law and equity go hand in hand. No one would doubt that from Be that as it may, it respectfully appears to me that here we have an issue that is being raised for the first time in the Supreme Court. And as Lord Justice Morbeck observed, it's a situation in which all facts potentially relevant to the correct determination of the viewpoint have not been found by the tribunal below. It's as simple as that. Now, if one goes further than that, and it's quite clear that they haven't been, Lord, let us be clear, because the relevant regulations are quite specific as to what must be established for permanent residence. It's necessary that the individual should have resided legally pursuant to Article 16 of the regulations. It's not simply a case of having been in the country for 5 years or 7 years. Residing legally means residence in compliance with the conditions in the directive. We know that. And there is simply no hint of that, other than a suggestion in the first appellant's statement that she had various employments as a cleaner in various parts of the United Kingdom. And that doesn't take one anywhere near the requirements for residing legally. Nor does it even begin to address, for example, whether or not there were circumstances in which she would have required health insurance, which would be a necessity in circumstances where she was not actually engaged in employment for periods of time, albeit only after the initial 3 months of residence in this country as an EEA citizen. So there is simply nothing there. But even if there was, my lord, the relevant test under 28.2 is serious grounds of public policy. And I would simply make the submission in those circumstances that an attempt to abuse your EU citizen rights by entering into a sham marriage does raise a matter of serious concern, in the context of public policy. It is of immense importance that such conduct should not be allowed, that such conduct should not continue. So there would be no material difference in the outcome if the matter was remitted back and it was found that she had an extended right of permanent residence pursuant to Article 16 of the directive. The other findings, in fact, remain in place. It's a matter of serious concern on grounds of public policy that an individual should abuse their EU rights in this way in order that someone who is here unlawfully should secure the means to remain. So I say, as regards the new case on Article 28, we should not go there because on the authorities it's quite clear that the relevant findings, in fact, were never made by the tribunal. And even if your lordships were inclined, as my Lord Kerr has suggested, that the case should go back to the first-tier tribunal for a determination.
I don't think I've suggested that. I'm merely
well,
mooting that as a possibility.
Well, that is why I seek to put it in that way, my Lord. I wasn't seeking to suggest that that was your intention, merely that you were raising the possibility. But one's got to bear in mind, in the context of deciding whether or not that step should be taken, that, in fact, the relevant test under Article 28, paragraph 2 of the directive, is addressing a matter of serious public policy, serious ground of public policy, and that's exactly what we're dealing with here. Immigration controlled in the context of the abuse of EEA and EU citizen rights. So that is where I would rest my submission, my Lord. Even if you go down that Article 28 route, it takes the first appellant nowhere from my submission.
Do you by any chance have Court of Justice authority for your proposition, which equates abuse of rights with serious grounds of
not immediately to hand, my lady, but I will endeavour to check the position on that definition, and if I may seek leave to pass such relevant authority to the court and to my learned friend.
Yes, fine, thank you.
I'm obliged. Lords, unless there's any further matter upon which I can assist the court, I would rest my submission for I renew my motion that the appeal should be refused.
Thank you very much, Advocate General. Mr. Webster. Mr. Bovey.
I didn't likely perform the volte-face on the issue of whether this matter was put because it involved withdrawing what I frankly considered to be the stronger argument, namely that it was unfair for the tribunal to reject the whole evidence of the appellants solely on the basis of a matter not put. But I did so under the compulsion of having received contemporaneous notes from the solicitors involved, demonstrating that in each case the cross-examination began of each appellant began with this issue, and so I felt compelled to accept that evidence in preference to the material on which I had based my earlier earlier submission, and I regret that I'm unable to defer to the Advocate General's assessment of what actually happened. I'm similarly unable to accept the punctuation perfect approach that he takes to the issue of mother, because if we look at paragraph 12.0 on page MS 100, you will see in the in paragraph O at the foot of page 100, it's paragraph 12.0, that the first tier tribunal says, the first appellant was found at Leith Registry Office and without either a friend or relative, yet her friends and female relatives live in the same town. Now, it was no doubt on the basis of the other passages and that one that it was accepted in the upper tribunal that the first tier tribunal was in error on the issue of where Miss Sadovska's mother lived, and I respectfully maintain my submission that the error exists in the first tier's assessment. Now, in relation to the issues of onus, dealing first with the European citizen, it is not the case in my submission that paragraph 7 on onus was ever correct in relation to Ms. Sadovska. An allegation of fraud in a capacity does not place proof of the capacity on the accused person. It puts proof of the capacity on the accuser. A claim for an entitlement in a capacity does put an onus on the claimant to show that she has the capacity, but that is not where we are. This person was accused that in the capacity of a EEA citizen, she attempted to enter into a sham marriage. And so both those elements, both that she was or claimed to be an EEA citizen, and secondly, the fact that it was a sham, they fell in my submission on the accuser, who was the Secretary of State. So in my submission, the paragraph 7 was never correct.
So if the Secretary of State had established to the satisfaction of the tribunal that the marriage was a sham marriage, to use that expression, but had led no evidence on the status of the appellant,
yes,
then she would have won.
Yes, that's right. That's right, my lord. Yes, I think that is right, because the sham marriage would just exist in a vacuum. It wouldn't have the necessary context. In relation to the case for Mr. Malik, and I'm responding, I hope, a little more fully to the point that Lord Reid put to me before lunch. if we look at paragraph 9 on page MS 97, we see under the heading, the respondent's case, the respondent believes that both appellants intended to enter into a marriage of convenience. It's the respondent's position that both appellants were interviewed at the Leith Registry Office on the 17th of April. Placing reliance on what was said, the respondent draws the conclusion that the first appellant prejudices her right as an EEA national, and the second appellant is an overstay who has attempted to enter into a marriage of convenience in order to fool the respondent into granting a right to reside as a family member of an EEA national. So that was the case that the respondent set out, and that being her case, it was up to her to show it. She made that allegation, and it was for her to show it, and the onus of showing that, she having made that allegation in my submission, it was always on her to show it. And we see something of that in the Aggo case at paragraph 45.
Well, I don't know that the Advocate General disputes that. He doesn't dispute that.
I wanted to make the point because I think Lord Reed's question about what was an appeal merited a little bit more analysis than I was able to give it on the hoof. So it may be that it arises from that interaction rather than what the AG has said. The reference in Aggo is at page MS 1084, and at 45, paragraph 45, at the foot of page 1084, the Judge, Lord Justice Underhill says, I wouldn't want it to be thought that I was blind to the unsatisfactory nature of the evidence adduced by the appellant as well as that adduced by the Borders Agency. And then there's a number of criticisms and 4 lines from the foot, but the case had to be decided on the basis that the evidence that there was. The burden was on the Border Agency to make good its positive case that the appellant and Miss Raducanu never lived together, and for the reasons I've given, I do not believe that the very limited evidence which it produced was capable of overcoming the inference to the contrary. So that is essentially the principle that I have sought to mention in operation in action. Now, in relation to the issue as to whether the permanent right of residence would have made a difference, it would, of course, have informed the proportionality assessment. And in my submission, that is a matter of some significance, particularly when the proportionality assessment has its own European context, and essentially the fact that a wrongdoer is still going to be in the European Union is a relevant part for assessing proportionality in this context, in a way that a wrongdoer who's taken away from the United Kingdom and out with the European Union, that doesn't apply. So in my submission there is a difference. Now, the Advocate General pointed out, obviously, that interviews on Monday, Tuesday or Wednesday might still have caused the marriage not to take place, because if the appellants had been detained. But of course, this interview took place at the very point at which the marriage was planned. Interviews thereafter, 2:30 on Thursday and onwards, they would not prevent the marriage from taking place. And the fact that it was happening at the very time had the effect of preventing the marriage, and there is no reason discernible from the eloquence of the Advocate General as to why it was appropriate not to allow the marriage to take place and to interview at 2:30 or 3 o'clock. The Advocate General indicated that the appellants had never married. That is the case, but they presented themselves to the Registrar's Office. They were told they needed Mr. Malik's passport. That has been retained by the respondent. Standing the respondent's views and on the relationship and her previous conduct in stopping the proposed marriage in 2014, that passport was not sought from the Home Office, but an attempt was made to marry since these events took place, and these appellants have, of course, been residing at the same address by reason of temporary, as each other, and by reason of temporary
Can I just ask
admission.
you about that? Because if there were to be a remission,
Yes.
one of the questions might be the relevance or otherwise of the position at the moment.
Yes.
So what is the position now as compared with what it was before?
The position is that they continue to cohabit at an address in Edinburgh where they are admitted, given temporary admission by the respondent. So they're both required by the condition of their temporary admission to live at the same address. Living at the same address, of course, not the same as cohabitation, but my information which I put before the court is that they are cohabiting. They're both present in this court today and have been obviously attentive in attending other hearings of the case over the years.
But they haven't made any further attempt to marry?
They've made one attempt to marry, but we're told that Mr. Malik's passport was required. That is a passport which continues to be retained by the Secretary of State. And I think the view was taken, given that the Secretary of State regards the matter as abusive, the prospects of her handing over the passport so that they could use it to get married were not good. So I don't think there's been a request to the Secretary of State for that passport. But they are they are as I've just said. Just finally, at paragraph page, the citation for the reference to applying the probabilistic yardstick, which I referred to in Karana Karan, is in the middle of page MS 1265. I think I referred to Karana Karan without a citation of the authority. One of the respondents' submissions cases, and the passage that I was drawing the court's attention to was between F and G and then G and H, and having considered, essentially what it says is that having considered everything, then we apply the probabilistic test for want of a better yardstick. And again, my submission is supportive of some of the other cases that the Advocate General has mentioned in this context, where the whole case is considered, but then reference is made to the test at the point of making the decision. Unless there's any other matter, I'm very grateful to the court for the opportunity to reply.
Thank you very much indeed. Thank you, Mr. Bovey. Well, we're very grateful to you, Mr. Bovey, and you, Advocate General, for your oral submissions. We're also grateful to all those who were involved in preparing the written cases that we found very useful. We will consider our decision in this first appeal to be heard by the Supreme Court in Scotland, and we'll let you know our decision in due course. Thank you all very much indeed. Thank you everybody for attending, and we will give our decision in due course, as I say. The court is now adjourned.